Professor Frost, we talked a little bit earlier about the extent to which we've got the record is replete with examples of tourism, birth tourism, in which there are, malactors who are profiting by moving people into, or transporting people into the United States to then deliver babies. So we have Georgetown Law report talking about women from foreign countries, China and Russia, paying tens of thousands of dollars to temporarily relocate to the United States, give birth, and then often return. We have that happening at the southern border with some regularity. In McAllen, we have it in Laredo, we have it in El Paso, throughout Texas. I certainly can attest personally. You believe that all of those children, regardless of why they end up on American soil, that those children are, in fact, U.S. citizens under the law?
I'm so glad you asked that, because there's actually a federal regulation, 22 CFR 41.31, which bars people from coming to the United States to give birth and gives consular officials the authority to bar anyone visibly pregnant from giving birth.
That's not the question. The question is these babies are born on American soil. These babies are born on American soil. They are brought here. They're brought here for profit. Are they citizens, yes or no?
Yes, they're citizens, and if you have a problem, enforce the regulation.
So the question is that they are, in fact, citizens under your interpretation of the law. Mr. McCotter, you noted just a minute ago that, in fact, Justice Harlan was the lone dissent in Plessy, correct?
That's correct, yes.
But was also a dissenter in Wong.
Right, he joined the Chief Justice.
So a threshold question here is, with respect to Wong, which is often cited as the basis now 130 years hence, for these individuals being viewed as citizens by now, in this instance, the most pernicious models, where people are profiting for bringing people into the United States to have babies, exploit our laws, go back to their countries, or exploit our laws for citizenship, that they are deemed citizens based on an interpretation of an opinion 130 years ago. Yes or no, Mr. McCotter, do you believe that Wong stands for that premise?
I do not, and I cite support for that in the brief.
You believe that it is limited to, at most, an LPR type status under today's law?
Right, here's a quote. Wong, by its facts and some of its language, is limited to children born of parents who at the time of birth were in the United States lawfully and indeed were permanent residents. That's from a professor at NYU.
Mr. Cooper, do you share that view?
I do share that view, and I would point out again that Wong itself conditioned its irresistible conclusion from the 14th Amendment. It affirms the ancient and fundamental rule of citizenship by birth within the territory in the allegiance and under the protection of the country, which was premised in that case on the parents of Wong being lawful permanent residents, allegiant to this country.
So to be clear, Mr. Cooper, you do not believe that that Wong's opinion extends, certainly at a minimum, beyond, again, what we would characterize under today's law as an LPR status individual?
No, it clearly just didn't have anything to do, as Mr. O'Brien has said, with illegal aliens or aliens here who may be here lawfully, but only temporarily.
And are you aware of any opinion by the United States Supreme Court that has extended beyond that interpretation since Wong?
No.
Mr. McCotter, do you agree with that?
I agree, yes.
Mr. O'Brien, do you agree with that?
I do.
And so now, having, I think, established that that is, in fact, the state of the law with respect to Wong and everything since Wong, now my question is Wong itself correct? We have an opinion by Mr. Justice Harlan. Justice Harlan, who was the dissent in Plessy, was Plessy later overturned? Mr. Cooper?
Yes.
Mr. McCotter?
Yes,
overturned. Mr. O'Brien?
Yes.
Professor Frost? Plessy was overturned.
Yes.
Now we've got Wong. Is Wong itself correct on the law with respect to even LPRs under the interpretation of the 14th Amendment? I would ask Mr. Cooper your opinion on that.
Well, I will tell you, Mr. Chairman, that I think there's significant support for the conclusion, the holding in Wong, in the debates under the Citizenship Clause. But one doesn't have to conclude that it is correct in order to uphold this executive order, because the executive order is entirely consistent with Wong.
Mr. McCotter, do you have anything to add to that? Mr. O'Brien, and then I will be done with my time.
No, sir.
Mr. O'Brien, anything to add?
I do not believe it was correct, and I would go so far as to say that the holding itself should be considered limited to the terms that were before the court, which had to do with a treaty with China, which is no longer in existence.
I appreciate it, gentlemen.